Good morning. Welcome to the Maryland Public Service Commission. The commission will come to order. Mr. Secretary, if you could please call today's docket.
Mr. Chairman, today's hearing concerns case number 969, Skipjack Offshore Energy LLC's qualified offshore wind projects compliance with conditions approved in 2017.
Thank you. We are on the record in this proceeding. This is a trial type evidentiary hearing noticed on March 12th, 2020, pursuant to order 89500, issued on February 13th, 2020. If I could ask everybody to please turn off their microphones at this time. Thank you. In that order, the commission determined that it was necessary to conduct an evidentiary hearing regarding the impacts related to the change in turbine size selected by Skipjack. As noted in that order, we have a little bit of an audio delay there, but I'll restate. In that order, the commission determined that it was necessary to conduct an evidentiary hearing regarding the impacts related to the change in turbine size as selected by Skipjack. As noted in that order, the scope of today's hearing is limited to the potential impacts related to the change in turbine size. We will begin today by taking appearances in the order in which the parties will present their case. Let's begin with appearances by Skipjack.
Good morning, Your Honor. Joseph Curran on behalf of Skipjack Offshore Energy. I am joined this morning by co-counsel Christopher Gunderson and Diana Crever. Thank you.
Thank you, Mr. Curran. The town of Ocean City, Maryland. Do we have anybody from Ocean City with us? Okay, we will proceed to the business network for offshore wind.
Good morning, Mr. Chairman and Commissioners. James McGee with the Law Office of Robert Castro on behalf of the Business Network for Offshore Wind.
Thank you, Mr. McGee. The Maryland Energy Administration.
Good morning, Arn Kushner on behalf of the Maryland Energy Administration.
Office of People's Counsel.
Mr. Chairman, Patrick O'Loughlin on behalf of the Office of People's Counsel. I'm also joined by Bill Fields, Deputy People's Counsel.
Thank you.
Mr. Chairman, Timothy Maloney, Leaf Proddy on behalf of the town of Ocean City.
Thank you, Mr. Maloney. Yeah, for the Maryland Public Service Commission.
This is Michael Dean on behalf of the staff of the Maryland Public Service Commission, and I would also like to enter the appearance of Lloyd Spivak.
Thank you, Mr. Dean. In terms of general housekeeping for this proceeding today, it's important that you speak clearly for the court reporter and that we avoid any crosstalk today. There is no need to rush. We'll take as much time as we need to get through this evidentiary hearing. If you are not speaking again, please turn off your microphone. That will cut down on a lot of the background noise and static that we've already heard this morning. I'll plan to call a 10-minute break approximately every hour and a half, and we'll plan to take a lunch break around 30 minutes today. Regarding rules of conduct for evidentiary hearings, I have rules regarding examination and regarding handling of exhibits. Regarding examination, witness examination will be limited to direct, cross, and redirect. If you are sponsoring an expert witness, begin by qualifying that witness. Cross-examination is limited to the scope of direct examination, and redirect is limited to matters brought about on cross-examination. If a commissioner chooses to question a witness, counsel will have an opportunity to further examine the witness based on the resulting answers. Additionally, participants on the same side of an issue may not cross-examine each other's witnesses on that issue. An objection to a question put to a witness during cross-examination may only be made by counsel sponsoring that witness, and requests for questions on clarification on cross-examination may only be asked by that witness. Finally, a reminder that cross-examination is not to be used as a substitute for discovery. Questions asked on cross-examination that are designed to educate a party regarding the substance of another party's pre-filed written testimony or otherwise obtain information that could have easily been obtained during discovery will not be permitted. Moving on to exhibits. Every exhibit offered into evidence must be properly authenticated and have a foundation laid prior to its admission into evidence. If parties seek to introduce a confidential exhibit, we'll need to pause the public feed and go into an in-camera session. I'd like to keep as much of this proceeding open to the public today, but if we need to introduce any confidential exhibits, we'll have to temporarily pause the live stream. Parties are discouraged from introducing discovery responses in lieu of cross-examination. And finally, because we're in a virtual environment today, when an exhibit is referenced during the hearing, the examining attorney has the responsibility of making a specific reference to the pre-filed exhibit so the commissioners and other parties will have sufficient time to poll the exhibits. I'll pause at that point and ask if there's any questions regarding the rules of conduct for today's hearing. Hearing none, we'll move on to preliminary matters. I understand that Skipjack has a motion before the commission opposing the introduction of portions of Office of People's Counsel's testimony. Before I address that, are there other concerns or preliminary matters to address? Okay, hearing none, we received a motion from Skipjack seeking to strike portions of witness Chang's rebuttal testimony as filed by the Maryland Office of the People's Counsel. We received an opposition response from Office of People's Counsel just yesterday. Upon review of both motions, I do find that Mr. Chang's testimony is outside of the scope of this proceeding. And I believe that the testimony fails on multiple grounds, at least 3 different grounds, and I'll explain. As I noted at the outset, this is a very narrow proceeding limited to changes and impacts regarding the selection of a different turbine model by Skipjack. The question of excess OREX would remain in any proceeding regardless of whether the size of the turbine is 2 megawatts, 12 megawatts, or 20 megawatts. Additionally, pursuant to state law, Public Utilities Article 7-704, this type of issue is to be raised in a rulemaking proceeding, not an evidentiary case-specific proceeding. Additionally, it's questionable, and I don't need to reach this point, but it's questionable whether much of the testimony by Mr. Chang is properly situated as rebuttal testimony. While there's no requirement that a party submit direct testimony in order to submit rebuttal testimony, I concur with Skipjack that much of this testimony is not properly before the commission today. I would go on to note that Mr. Chang, at least on 4 occasions in his testimony, recommended that the commission should open, quote, a proceeding, not this proceeding, but a proceeding. And Office of People's Counsel in yesterday's motion goes so far as to say that while this issue is ripe for determination, I quote, either in this proceeding or if the commission should choose in a separate case, end quote, favors Skipjack's response in this case. Commission makes no judgment regarding the content of that testimony, but that testimony is struck for purposes of today's proceeding without prejudice for introduction in any other proceedings that may occur. And Mr. Coran, I would just note for the record, with respect to footnote 1 of your motion to strike, you're not opposing Mr. Chang's rebuttal testimony regarding cost-saving sharings conditions, although your footnote says, see Chang rebuttal at section 4, I believe section 6 Is that correct?
I believe so, Your Honor, yes.
All right. So for the record, Skipjack's motion to strike portions of the rebuttal testimony of Mr. Chang is granted. Mr. Chang may testify with respect to Section 6 of his rebuttal testimony.
Thank you.
At this point, if there's no additional preliminary matters, we will begin with opening statements to the extent parties wish to make an opening statement, beginning with Skipjack.
Thank you, Your Honor. Thank you, Mr. Chairman and Commissioners, for granting Skipjack the opportunity to appear before you this morning to discuss the impact of its selection of the General Electric 12 megawatt turbine for our Skipjack project. We are presenting, Your Honors, a handful of witnesses this morning, which we hope will be providing the Commission with meaningful information, not only on the turbine selection, but the actual attributes of these most advanced turbines. We contend that, which was both concurred by the Maryland Energy Administration and the staff, your staff, that really the principal impact of this selection is that we're going with a much more advanced and efficient turbine than the 8 megawatt turbine that had been discussed during the 2017 proceedings. It provides a higher average output, which means essentially on a per turbine basis, it's producing more clean power, which we contend helps Maryland meet its increasing renewable portfolio goals. Another significant impact of the selection, Your Honors, is that it will result in the need for fewer turbines to meet the OREC requirement that the Commission outlined in its 2017 order. There'll not only be fewer turbines, but they'll be further away from the shore than the 8 megawatt outlay that we discussed in 2017. And as a result of being fewer and further away, they'll actually occupy less of the visible horizon than the 8 megawatt outline. I'd also note, and it's important for the Commission to know, that in no way will this selection impact any of the company's commitments to the Commission that were outlined in the 2017 order. I'd like to briefly introduce our witnesses. We've provided 5 witnesses for the Commission's edification. We'll be starting off this morning with Mr. Jens Gravgaard. He is an engineer. He's the project manager for Skipjack, who's been leading this effort since December of last year. Mr. Gravgaard has over 20 years of experience in offshore wind development and has worked on over 20 offshore wind projects. The purpose of calling Mr. Gravgaard is to assist the Commission in understanding some of the technical aspects and output capability of the 12 megawatt turbine, and to discuss the differences between the 8 megawatt turbine and the 12 megawatt class. The simple fact from this selection, as I mentioned earlier, and Mr. Gravgaard will outline this, is as a result, there will be fewer machines and they'll be further away from the shore. Due to the COVID-19 pandemic, Mr. Gravgaard is appearing this morning from his offices in Denmark. He hopes, once the situation with COVID-19 relaxes, he'll be able to return to the United States soon. Our second witness, Your Honors, is a gentleman, Mr. Gordon Perkins. He is an experienced visual simulation specialist, and he'll be able to discuss with you all the visual impact differences between the 8 megawatt outlay and the 12 megawatt design. We hope that you all have received copies or hard copies yesterday of Mr. Perkins' visual simulations. We contend that they demonstrate that the 8 megawatt configuration had positive visual attributes, but we contend that the 12 megawatt is even better due to the fact that you have less visible horizon impacts from this. Our third set of witnesses are Ms. Joy Weber and Brady Walker. We're presenting them to you all as a panel of witnesses. Ms. Weber spoke, if you may recall, during the public comment hearings in Ocean City back in January. Both Ms. Weber and Mr. Walker are here in our Maryland offices for Skipjack, and they have led the community and governmental outreach effort since the project was approved back in 2017. There's been some discussion in the testimony about concerns over our communication and outreach efforts, and Mr. Walker and Ms. Weber will be able to answer the Commission's questions regarding that, as well as the broad array of stakeholders that they've been able to meet with on a routine basis, not only at the local level, but at the state and federal level as well. And then our last witness, Your Honor, is Dr. Corey Lang. He's a professor at the University of Rhode Island. And while the Maryland General Assembly and this commission has made the public policy determination some years ago that Maryland will be pursuing offshore wind as a development effort in reaching our renewable goals, we thought it was important to call Dr. Lang in order to respond to some concerns that have been raised in Ocean City's testimony. Specifically, Dr. Lang is the co-author of the only study to date on tourism impacts of an actual operating wind farm here in the United States. It's in reference to the Block Island Wind Farm up in Rhode Island. And based on the study that he's provided the commission, as well as his review of the literature on offshore wind, Dr. Lang has been able to conclude that our selection should have no negative impact on tourism. And in fact, his study has shown that quite the opposite, that there's been a positive impact on tourism in the Block Island region. So what we've tried to do with our witnesses, Mr. Chairman, is to remain very focused on the limited nature of these proceedings and the commission's order. In some, we contend that we're presenting the most advanced turbine for Maryland. It has positive visual attributes that will be explained. But also, most importantly, Maryland will now have the most efficient turbines that are available now on the market to produce more clean energy for the state. And as a result, we hope at the conclusion of these proceedings that the commission will conclude that there's no need for any further action on this other than to allow the company to continue with its development efforts and to continue to meet the many obligations that have been presented to the company in the commission's 2017 order. Thank you.
Thank you, Mr. Corinne. Would the town of Ocean City like to make some brief opening remarks?
We would. Thank you, Mr. Chairman. Mr. Chairman, we would like to begin first by thanking the commission for holding the well-attended public hearing in January in Ocean City. We would also like to thank the commission for holding this important evidentiary hearing, although the town of Ocean City regrets that this hearing was not postponed so that it could be held in Ocean City, convenient to the community at a later date. The town of Ocean City supports renewable energy. They are not opposed to wind turbines. Instead, they are opposed to locating wind turbines in the historic and iconic Ocean City viewshed. And they ask the commission to protect this viewshed in these proceedings. Ocean City is in favor of the jobs that the Skipjack project will create and the economic benefit that will come from that. But as Ocean City has consistently and repeatedly stated to Skipjack and to the commission, the right steps, the right measures need to be taken, and the right location needs to be selected. These wind turbines will be off the coast of Ocean City for decades, if not generations. What Ocean City is requesting here is that the turbines be moved farther out from the shoreline and out of its viewshed. We have heard over the years different figures from Skipjack as to how close the turbines will be to the Ocean City shore, and none of them are definitive even now. There needs to be certainty here. This cannot be a game of constantly shifting locations. The OREX need to be conditioned upon specific locations which will protect the Ocean City viewshed for generations. When Skipjack originally applied for the OREC credits, it stated that the project would be 17 to 21 nautical miles from Ocean City, which is apparently 19.5 to 24 statutory miles. Skipjack then stated that the 8 megawatt turbines would be 19.5 miles from the shore. At the public hearing in January, less than 5 months ago, Skipjack stated that the closest point in Ocean City to the project would be, quote, about 20 miles away. Skipjack then stated that the project was now, quote, expected to be at its closest, approximately 22.7 miles from the Maryland coast. That has since been revised, so now that the project will be located at its closest between approximately 21.5 miles using a 12 turbine layout or 22.7 miles using a 10 turbine layout. There is nothing that currently prevents Skipjack from building the turbines as close to Ocean City as their lease area allows. We need viewshed protection and we need certainty. The Commission's May 11th, 27 order conditioned its OREC award on the applicant's, quote, use of the best commercially reasonable efforts to minimize the viewshed impacts of their respective OSW projects, regardless of the outcome of the federal review process. It's from page 45 of the order. Skipjack has not met that condition. There is no evidence that they used any effort, let alone the best commercially reasonable efforts, to pursue any other location farther out than what they propose here, even though Ørsted has wind turbines or is developing wind turbines on Long Island in New York near the Hamptons, which are 30 and 35 miles offshore, respectively. The turbines that Skipjack seeks to use will be the largest in the world. They will be 850 feet tall, 3 times the height of the tallest building in Ocean City. As Skipjack's own witness, Gordon Perkins, responded in Discovery, 82% of the entire turbine could be visible to the naked eye from the shore under certain viewing conditions. This means that 702 feet of the turbine will be visible. He further responded that 70% of the most visible distant 12 megawatt turbine under the current layout would be visible, which is 597 feet. There can be no dispute that the 12 megawatt turbines will be visible and noticeable from the Ocean City shore and from the town itself. In this hearing, you will hear from Robert Sullivan, one of the leading experts in the world in the field of visual impact analysis. Mr. Sullivan has made thousands of observations of wind energy facilities. He will testify as to the problems with Skipjack's simulations and how they do not accurately reflect what the human eye will be able to see from the shore, including the spinning 350-foot blades. These turbines can and should be moved 30 to 33 miles from the Ocean City shore. Ørsted has other projects on the east coast of the United States that are more than 30 miles. The South Fork Wind Farm, in development off the coast of Long Island near the East Hamptons, will consist of 15 turbines located 35 miles from Montauk Point. Ørsted even puts on its website that, quote, the project will be out of sight from the Long Island beaches, unquote. It cannot put that on the website for this project here for Ocean City. Why not? Ørsted's Sunrise Wind project is planned for development 30 miles east of Montauk Point in Long Island. Another project not theirs, the Coastal Virginia Offshore Project, is planned for 27 miles off the coast of Virginia Beach. If regulators in those states can protect their beachfront communities, then the Maryland Public Service Commission must do the same for Ocean City. In its May 11, 2017 order, the Commission found that, quote, there is a strong public interest in ensuring that the impacts to the viewshed as a result of an offshore wind project are minimized to the fullest extent possible. That finding was further supported by the more than 1,000 citizens and residents who appeared at the Commission's public hearing in January, on January 18th of this year. Citizens and property owners spoke about the negative impact on their views, on their property values, and on the effect of their tourist-reliant businesses, which today in this environment are more fragile than ever. You will hear in these proceedings from Mayor Meehan. He has been on the Ocean City Council for at least the last 35 years, 14 as the city's mayor. He knows what draws the city's nearly 8 million annual visitors to Ocean City. He knows the concerns that the Ocean City businesses and its hotel and condominium associations have about the negative impact these turbines will have on their priceless view shed. He has spoken with residents and property owners in Ocean City that have similar concern and voiced their concerns about the visibility of these massive turbines. Now, you have heard that there has been testimony, or will be, from Skipjack about the Block Island wind farm in Rhode Island. You will hear, however, that Ocean City is profoundly and manifestly different from Block Island. In its order in 2017, the commission, quote, specifically conditioned its award on the applicants continuing to work with Maryland citizens and local, state, and federal authorities in addressing all applicable environmental, visual, and other impacts of public concerns. Skipjack made its determination to use 12 megawatt turbines at a distance of 21.5 to 22.7 miles without ever first discussing this change, submitted its COP with plans for the 12 megawatt turbines. In fact, Ocean City learned most of Skipjack's plans by intervening in these proceedings and obtaining discovery, and not from any consultation or collaboration with Skipjack. This is despite the explicit orders from this commission to, quote, continue consultation with stakeholders directly affected by the view shed, quote, and to have a, quote, ongoing dialogue with these stakeholders regarding any changes to the siting and turbine model selection contemplated by the application pending here. Skipjack clearly did not comply with the commission's order in this respect, just as it did not comply with the commission's most important condition, the condition that it, quote, use the best commercially reasonable efforts to minimize the impact on the view shed. Given the visibility of these turbines, Ocean City is asking that the Skipjack project be moved further from Ocean City coast to, quote, minimize the view shed impact of the project, consistent with the commission's 2017 order. The commission needs to protect the interests of the Maryland residents and the Maryland beachfront communities. Although the 2017 commission order said the view shed would obtain additional protections from the BOEM, the Bureau of Offshore Energy Management proceedings, now after 3 years, we know that not to be true. To date, BOEM has demonstrated little interest in protecting the Ocean City view shed. The 8 million visitors to Ocean City cannot rely upon BOEM for protection. That is why the mayor and council asked the Public Service Commission to protect the Ocean City view shed in these proceedings, just like regulators in other states have done for their beachfront communities. I thank you, Mr. Chairman.
Thank you, Mr. Maloney. Would the Business Network like to make a brief opening statement?
Thank you, Mr. Chairman. My client supports Skipjack's application and respectfully requests that you approve it. Thank you.
Thank you. Counsel for MEA?
Thank you, Chairman. MEA simply looks forward to participating in this evidentiary hearing. We have a single witness, Samuel Byrne, Energy Program Manager, who will testify further as to MEA's position on the impact stemming from the change in turbines for the Skipjack project. That's all.
Thank you, Counsel. Office of People's Counsel?
Good morning again, Your Honor. Thank you. Based on your ruling on Mr. Chang's testimony, we will be presenting testimony from Mr. Chang that provides information solely on the sharing provision in Order 88192 from Case 9431, and provides its recommendation on continuing reports on the engineering, procurement, and construction costs alone. That's all. Thank you.
Thank you, Mr. Laughlin. And finally, yes, staff.
Good morning, Chairman, Commissioners, Michael Dean. Staff will be presenting one witness today, Mr. Lowe. We look forward to presenting that evidence for your use. Staff has nothing further to add at this time.
Thank you, Mr. Dean. Mr. Karen, you may call your first witness.
Thank you, Your Honor. The first witness that Skipjack will be calling this morning is Jens Hieronymus Gravgaard.
Thank you. Mr. Gravgaard, if you raise your right hand, you'll be sworn in by the court reporter.
Sir, can you hear me?
I can.
Okay. Before I swear you in, Mr. Chairman, I was muted before, but who was the attorney speaking for Ocean City?
It was Timothy Maloney.
Okay, thank you. Okay, that's what I thought it was. Okay, sir, do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Gravgaard, thank you. Could you please state your occupation and title for the commission?
I'm the Program Development Manager for the Mid-Atlantic Program, which includes Skipjack and Ocean Wind.
Thank you. And what is your current business address, sir?
100 Oliver Street in Boston. I cannot be there right now because of the COVID-19 situation, but that is where I work.
Where are you testifying from this morning?
I'm testifying from our headquarters in Copenhagen.
And sir, is this the first time that you've testified before the Maryland Public Service Commission?
Yes.
Gravgaard, do you have before you a document that has been marked as Skipjack Exhibit 1, entitled, yes. It's entitled The Direct Testimony of Jens Hieronymus Gravgaard, dated April the 17th, 2020, consisting of 12 pages and 2 exhibits, along with an errata to that testimony that was filed on the commission?
I do.
Okay.
Yes.
And you also have before you a document that is marked Skipjack Exhibit 2 that's entitled The Rebuttal Testimony of Jens Hieronymus Gravgaard, consisting of 6 pages and no exhibits.
Yes.
Now, sir, were these testimonies prepared by you or under your supervision?
Yes.
And do you have any corrections or additions or deletions to your testimony this morning?
Yes, I have a correction to my direct testimony on page 8, and that is on line 7.
Let's give everyone an opportunity to get to page 8. This is your direct testimony, sir?
Yes.
And what line are you on? I'm sorry.
I'm on line 7.
And on line 7 on page 8, what is the correction that you would like to make to your testimony?
It is after the word located. It should read located from 2 to over 3 miles farther from the Maryland coast. So I insert 3 words. From 2 to over 3 miles farther from the Maryland coast.
Well, thank you. Other than that edit on page 8 of your direct testimony, if I were to ask you the same questions today that are contained in both your direct testimony and your rebuttal testimony, would your answers be the same?
Yes.
And are these testimonies, Mr. Gravgaard, true and correct to the best of your information, knowledge, and belief?
Yes.
Your Honor, at this time, Skipjack would respectfully move Skipjack Exhibits 2 and 3 into evidence.
Mr. Kren, did you say 2 and 3 or 1 and 2?
Sorry, I am so sorry. Exhibits 1 and 2.
Exhibits 1 and 2 of Skipjack are so marked and moved into evidence.
Thank you. Your Honor, we have no live rejoinder for Mr. Gravgaard, and at this time he is available to counsel for cross-examination.
Thank you. We'll begin cross-examination by counsel for Town of Ocean City.
Mr. Grabgard, good morning or good afternoon in Copenhagen, I think.
Good afternoon.
The change that you just made, the correction on the errata sheet, what was in terms of going from 2 to over 3 miles, was there any substantive change in the rest of your testimony, or what necessitated that correction?
It is just a level to reach the proper level of accuracy. You can see it relates to these two lines with a number of turbines in, and it means that we have counted in the first line of those.
I don't understand your answer, so let's break it down.
Okay.
Are you saying that this means that there would be a farther out potential line of the turbine, or what exactly are you telling the commission led to this correction from saying 2 to, quote, over 3 miles?
Yes. So the 2 miles is we look at the closest turbine of those turbines, that is 19.5, right?
Right.
Okay. So that represents the 2 miles compared to, yeah.
Right. The over 3 miles represents what number?
If there were only 10, then it would be further out.
When you say if there were only 10 turbines?
If there were only 10 turbines.
And how many will there be? Will there be 12 or 10?
We don't know yet.
So you're asking the commission to approve the turbines, not knowing whether it would be 12 or 10, and not knowing whether it would be 19.5 or maybe 22 miles offshore. Is that correct?
Can you repeat that, please?
So in other words, Skipjack is asking the commission to approve the OREX, not knowing whether it will be 10 turbines or 12, not knowing whether it will be 19.5 miles offshore or perhaps farther offshore. Is that correct?
That's correct.
And when you say that it goes from 2 to over 3 miles, what is the distance that over 3 miles would be? In other words, what is the minimum and what is the maximum in terms of actual statute miles from the shoreline?
That is represented by the 22.7.
22.7?
Yes.
Could it be farther than 22.7?
Not much.
And why is that it could not be not much farther than 22.7?
That is because this is consistent with the application that we have filed, the so-called COP, that we have filed to BOEM.
Is there any restraint on you going farther? What is the maximum level, so the record is clear, that your BOEM COP application would allow you to go out?
That is for the closest or the farthest turbine?
Both.
So the farthest turbine cannot go beyond the limit or the boundary of the lease area.
And what is that?
I couldn't tell right off the top of my head.
All right. And what is the COP? What is the COP that you've allowed for the farthest that you could go out?
Sorry, could you repeat that? What is the what?
What is the farthest that you say asked to go out under the COP?
Let me say. Is it something that I have put in my direct testimony, or what are you referring to? Or just an open question?
I'm referring to under the COP. What's the farthest out that these turbines could be located under your COP? Very simple question.
Yeah, so I don't know off the top of my head, sir.
Okay.
I would have to look up on drawings and check that.
Is it an accurate statement that there is nothing that precludes you from going out farther than 22.7 miles, other than the terms of the BOEM lease and the COP. Is that correct?
You could say that, yes.
Okay. Now, I'd like to ask you some more about matters in your direct testimony starting at page 9. You state that the 12 megawatt turbines that Skipjack intends to use are 33% taller than the 8 megawatt turbines in the 2016 application. Is that correct?
I'm sorry, counsel, what page are you on?
Page 9. Is it accurate that these are 33% taller than the 8 megawatt turbines that were presented to the commission in Skipjack's 2016 application?
I'm not sure I follow you. Not on page 9, at least. I believe there is a table on page 10.
All right, well, let's take a look at that. The question is simply this. Is it true that these 12 megawatt turbines are 33% taller than the 8 megawatt turbines that were in the 2016 application?
Yeah. When you look at the tip height, you can see that.
Okay, and so doing the math, that means the 12 megawatt turbines are about 212 feet taller than the 8 megawatt turbines, correct?
That is what the table says.
Okay. Now, Ørsted currently does not have any wind farm projects that have been built using the 12 megawatt turbines. I'm not talking about New Jersey where there's been an approval. I'm talking about where it has been built, correct?
That is correct. There is only one such turbine which has been built. That is the 12 megawatt turbine, which is the prototype, which is erected in Rotterdam.
Okay. That's the only one in the world right now.
Correct.
And the 12 megawatt turbine model is no more well suited to the wind conditions in the mid-Atlantic than the 8 megawatt turbine. Isn't that correct?
That is not correct.
Well, at page 3 of your testimony, you basically try to say they're comparable. Is that correct?
What line are you referring to on page 3?
Please. I'm referring to the entire testimony.
I would disagree with you, with all respect.
All right, and that's what you're here to do today, if you disagree. So go ahead and tell us how much more well-suited the 12 megawatt turbine model would be than the 8.
So if you look at wind speed, at a specific wind speed, the 12 megawatt turbine is more efficient, even when you compare it to its rating. Now, of course, a 12 megawatt turbine at a given wind speed produces more than an 8 megawatt. In addition to that, you can say that even if you divide by the rating, it is even more efficient. And that is because it has got a bigger rotor compared to its generator size. So it is actually a very, very efficient turbine we're looking at.
You're telling us the principal advantage here, obviously, of the larger model is the efficiency, correct?
It is one of them. We have listed here a number of reasons for selecting this.
Is the 12 megawatt turbine more reliable than the 8 megawatt?
That's our expectation, yes.
And what do you base that on?
We base that on our due diligence that we have, that our due diligence team have carried out.
And what makes it more reliable?
I don't know. I rely on the knowledge of our technical due diligence team, and they have issued a statement about it. There's a memo which describes that.
All right, but you yourself don't know, is that correct?
That is correct.
And will the 12 megawatt turbine model require as much maintenance or more?
Well, if you look at it relatively, since there are less of them, they require less maintenance.
Well, on a per capita basis, though, or per unit basis, they don't require less maintenance. In fact, they probably require more because they're bigger. Isn't that correct?
I wouldn't say that.
Well, are you telling us that on a per unit basis, each unit, a larger 12 megawatt unit would require less maintenance than an 8 megawatt unit? Is that your testimony?
I would say that because every generation has got improvements on most parameters.
Well, that's not true of the Volkswagen or the Coke. You don't know for a fact that that's true here, is it?
Objection, asked and answered.
Sustained.
Now, the 12 megawatt turbine, to be clear, was not selected by Skipjack with the view shed impact in mind. It was selected because that's where the market was going and because of the larger capacity. Isn't that correct?
We have looked at all these parameters, and we consider the difference in view shed as acceptable here. And I would like to defer to Mr. Perkins' testimony in that respect.
Well, you're telling us he's the view shed expert, not you, correct?
That is correct.
But you're not telling us that the 12 megawatt turbine was selected because it would be better to minimize the view shed. That's not a correct statement, right?
I would say that with the layout that we have presented here, it occupies a smaller part of the horizon.
All right, I'm going to ask you about the layout in a minute, but what drove the 12 megawatt selection, moving from the 8 to 12, was not a view shed impact. That was not the reason you switched. Isn't that correct?
Objection, asked and answered.
It was asked, but it wasn't answered.
I'm going to overrule. Council's asked that question several times. We haven't heard a straight answer from the witness. If the witness could answer that question, then we can move on.
Okay. There are a number of parameters that we have looked at here. And if you look at how we have mitigated this issue, is that actually we have positioned the turbines, less of them, in two lines. And when you look at how much of the horizon, when you look up to the ocean, they're going to occupy less of the horizon than the 8 megawatt layout is going to do. So that is how we have dealt with it.
Respectfully, sir, my question was not about the mitigation, but isn't it true that view shed impact was not the reason that motivated Skipjack to go from the 8 to 12 turbine? Isn't that true?
I think that is a matter of opinion, because proportionately they take up very little of what you can see out there, and that is what Mr. Perkins is going to tell you. It's not a major concern here, I would say.
Now, the 12 megawatt turbine, and why is it not a major concern with you?
Can you repeat that, the first part of your question?
And why is it not a major concern?
Because it takes up such a small part of the horizon, you see. I think I've said it before.
Now, the 12 megawatt turbine has not yet received the IEC type certification from the International Electrotechnical Commission. Is that correct?
Yes.
Has it obtained it or not?
It has not. It has not. It has not obtained the type certification.
Has that certification even been requested?
From General Electric?
Know whether or not the IEC has been requested to certify the 12 megawatt turbine or not?
I don't know. I cannot answer that accurately. It is definitely scheduled and planned, but whether the application has been filed, I can't say.
And since 2017, obviously the market changed, with the market moving from an 8 megawatt turbine to a 12. If the market changes again after these proceedings today to an even larger turbine size, would Skipjack consider using that for this project?
So we couldn't do that because in the COP that we have submitted, we have indicated a so-called envelope, which is actually the maximum diameter and height, etc. So we have an envelope which defines an interval of dimensions, and we couldn't fit a larger turbine within that envelope.
Well, you could always amend the COP to expand or change the envelope, just like you made changes since 2017 to accommodate the 12 megawatt. Isn't that true? There's nothing stopping you from doing that, is there?
That is correct, but it is not our intention.
Well, if you say it's not your intention, if the new model of 14 megawatt or 16 megawatt now becomes the industry standard next year, the year after, are you simply going to move to those models if that's where the industry and the market goes?
No.
Why is that? When you say no, how can the commission rely upon that?
Because that is what is stated in our application for the COP.
So are you willing to be?
That is what we are requesting here.
Are you willing to have the OREC bound and committed to the 12 megawatts and not any other size?
Isn't this a hypothetical question? Right now, we're just talking about the change from 8 to 12.
Well, as we have seen from the last 3 years, sir, there's nothing hypothetical about it. So the question is, if the market continues to move in a bigger direction as it did for the last 3 years, do you agree to be bound in the OREC conditions with the 12 megawatt size? So we don't have to come back here and do this again.
We have made this application and it expresses our intention.
Well, do you have any objection or do you agree that if the commission conditions this on a 12 megawatt size, that you would agree to live with that?
We could live with that.
And with respect to the locations, are you agreeing to be bound by the specific locations in your most recent layout as a condition of the OREX, or whatever reasonable location conditions are imposed by the commission?
That depends on what they are.
All right, but is it your position that if you believe they're reasonable, that you don't object to the concept of location conditions being placed on the OREC approvals?
So if they are consistent with what we have submitted here and what we have submitted with the COP, I would be fine with that.
Now, is the 12 megawatt turbine scheduled to become available for delivery in 2021?
Yes, that is what that is actually what the support letter from GE says.
Do you expect any delays in it?
No, I don't have any reason to expect any delays.
I want to ask you, 21, do you have that there?
Exhibit 21.
Are you referring to Ocean City's exhibits?
No, Skipjack's revised supplemental response to staff request 3.
Mr. Maloney, if you could provide a reference to what exhibit we're looking at.
I'm sorry, it's Ocean City Exhibit 21.
Supplemental revised response to staff data request 1-3.
That is correct.
Let's give everybody a moment to that. The witness have a copy?
I do.
Okay, Mr. Maloney.
All right. Does this 21 show the final layout of the Skipjack project?
It actually says or qualifies that while the final layout, number of wind turbines and distance will be definitively established in connection with the final engineering and permitting on the schedule, we expect that the project will be arranged in a grid pattern, like we say here. And that is our expectation. So when we talk about changes in layout here, we talk about small changes, but the pattern we see here, we could meet an obstacle. There could be a huge boulder on the seabed, etc. That would make us deviate slightly. But by and large, this is our intention.
All right. And this is, as far as you're concerned, other than some non-material changes or unanticipated geological factors or engineering factors, this would be your final layout. Is that correct?
Yes.
Is there
I have to qualify that because this is actually what the BOEM and the NEPA process, etc., are there for. It is actually so that there can be a public debate and discussion about it, and it's going to be addressed in a number of meetings. So there can be other interveners in this process than Ocean City, and actually BOEM could make other demands, but this states our intentions.
Well, respectfully, sir, it's all going to be addressed here, isn't it? That's why we're here today, correct?
That is correct. But after these proceedings, there are public hearings and meetings that we support BOEM in doing, where other people can state their opinion.
All right. And it's possible, there's nothing to preclude you from moving this even closer to the shoreline if you wanted to. Isn't that correct?
Of course, there are a ton of obstacles. There are shipping lanes, etc. They are also mentioned elsewhere in testimony that we have to respect. There's a 2 mile boundary, so we cannot just move them to anywhere closer.
Sir, I'm not asking about 2 miles offshore or the shipping lanes that are 9 to 10 miles offshore. I'm saying, hypothetically, if you wanted to move these in 5 miles or 6 miles, there's nothing in the OREC conditions or nothing anywhere else that would stop you from doing that. Isn't that correct?
I wouldn't say that because this is an expression of our intentions and our commitment, that is to place them where we are seeing it here.
Sir, I recognize this is an expression of your intentions, but there's nothing in the current regulatory approvals that would stop you from changing those intentions and going closer to the shore. Isn't that correct?
Objection, both asked and answered, and he is not an attorney to know what the status of regulatory approvals are that would allow that change.
I think he's shown himself to be quite knowledgeable in that area.
Overruled. If the witness could attempt to answer that question one more time. Mr. Maloney, you do want to rephrase one more time, and if the witness could please listen carefully.
There's nothing that limits or other than issues like maritime lanes or something like that. There's nothing in your current regulatory approvals that precludes you from changing your intentions to move these closer to the shore if you wanted to.
Formally you can say that is correct, but this is why we are stating our intentions here.
All right. We recognize intentions, but intentions, we know what road intention paves. We're asking you about what the restrictions are by law, and you're aware of no restrictions by law that would stop you from moving this, say, 5 miles inland if your intentions changed. Isn't that true?
Objection.
I'm going to sustain it this time. Mr. Maloney, I believe you received your answer from the witness.
Thank you, Mr. Chairman. And with respect to the number of turbines, wind turbines that would be there, there's nothing in the approvals that would stop by the state or BOEM or anywhere else that would stop Skipjack from having more than 12 turbines. Isn't that correct?
We are applying now for this change, and in this application, we have stated that is no more than 12 for this current OREC.
We understand that is your current intention. Question is a different one. There's nothing in the current regulatory approvals that would stop you from having more than 12 turbines if you change your intentions. Isn't that correct?
Objection.
Overruled. Witness may answer the question.
Now we are applying here for a change from an 8 to a 12 megawatt turbine, and we will place under this order, we will place no more than 12 turbines if this is granted.
You would agree that the order be conditioned to that, is that correct?
I would be fine with that. Thank you.
Now, when you submitted this layout to the commission, it anticipated your intention to build a row of wind turbines that were parallel to the coastline from the shore. Isn't that correct?
You're talking about the previous layout?
I'm talking about what your intentions is right now. Will these wind turbines that are set forth here, will they be set forth parallel? Will they be parallel to the coastline, or will they be perpendicular to the coastline, or otherwise?
I'm still looking at Exhibit 21 from Ocean City, and this is a representation of our intentions.
Right. My question is,
that is perpendicular to the coastline.
That's my point. Your current plan is to have them perpendicular. Is there anything that would prevent you from changing the perpendicular layout to a parallel layout to minimize the impact on the view shed?
Sorry, I don't follow you, because now this is this actually does minimize the view shed from the coastline.
Well, the extent to which it minimizes is the subject of this hearing. But my question to you is a different one, which is this. To further minimize the impact of the turbines, did Skipjack consider a layout that was parallel to the shoreline rather than perpendicular?
We have considered a number of different layouts here, some that are represented in our earliest submissions, which are more, shall we say, random in position, because that is typically the most effective. But after consultations now, also with fishermen and mariners in general, this is what we are committing to. So they are placed in a grid now.
Did you propose to the mariners or the fishermen or anybody else a layout in which the wind turbines would be parallel to the shoreline instead of perpendicular?
I don't know.
Did you even consider it at all, or do any analysis as to whether or not a parallel layout would be feasible, practical, or commercially reasonable?
Excuse me. So just to understand your question, do we agree now that right now the turbines are placed perpendicular to the coast?
Correct.
Approximately. So, and you're asking whether they are parallel. That means 90 degrees from now, from this one.
Correct.
that it would be possible.
All right. Is there anything that you're aware of that would make it commercially unreasonable to have them laid out that way?
Except that it would actually make the visual impact worse.
Well, have you done any studies to determine whether that's true or not, or is that just?
I think I can do that just by doing a little bit of geometry here, because if you did arrange them perpendicular here, they would occupy more of the visible horizon.
Well, that would depend where they were, how far they were located out.
Still within the lease area.
Right. So in other words, you're saying it's possible to do a parallel layout, but it's not something that you think was analyzed or considered. Is that correct?
I cannot speak to the number of layouts and precisely how they have been done. And I know we do dozens of layouts where we estimate what production can come out, and we look at the view shed, etc. on this. So it is very likely that this has been considered, but I don't know for sure.
Did you do any layouts that were farther than 22.7 miles?
I don't know.
Assuming hypothetically that BOEM could give you approval to go beyond 22.7 miles, is there anything that would be commercially unreasonable about Skipjack locating these turbines 30 miles offshore, such as the ones that are located 30 and 35 miles offshore of Long Island in your project up there?
As long as they are within the lease area and the boundaries of that, I have to state one thing here. There is a remainder of that lease area, and that represents the value to Ørsted. And if we sterilize that by preventing us from utilizing the rest, our company would suffer a tremendous loss in value.
Well, I want to explore that statement you just made. When you say there is a remainder area of the lease area that is valuable and would be lost if you use that, what do you mean?
I mean, there is an ongoing solicitation here with the state of Maryland, where, of course, it can be explored whether you could add more turbines to this lease area, for example, in the Garden State wind area.
So is the reason, one of the reasons you don't want to go out farther as permitted under the lease area is because you want to keep that in reserve for further wind approvals from the state of Maryland?
Objection, Your Honor.
Sustained.
Well, I'd like to be heard on this, Mr. Chairman. He's made a very important statement that they might be able to locate the wind turbines further out in the lease area, but that it would result to some economic impact to the company because they want to keep it in reserve for future approvals. And that's extremely important here. And the commission needs to understand that and to weigh those issues against the view shed and the other impacts that are here, so it can determine the commercial reasonableness standard under its 2017 order. So I'd like permission to reasonably explore the issue he specifically testified to, that they could go further out in the area that they're reserving and why they're not going out there.
I'll let you question further to the extent of financial impact to the company if they go further out, but we'll limit it to that.
Thank you, Mr. Chairman. So what would be the financial impact to the company that you just described? As you said, it would be a serious financial impact to the company if you were to go further out in the leasehold area than you already have. what would that financial impact be?
That depends on the terms under which it is done.
Well, describe in general terms how there would be any financial impact on the company at all if you were to move these wind turbines farther out from the shore in your existing lease area. How would that have any financial impact to you at all? What concept are we talking about here?
Well, for the specific project, it would increase the amount of the length of cables to get to the turbines. That is a very tangible and specific impact here.
Well, but you testified to something different a minute ago. That you had very important areas farther out that would be very expensive to the company to locate there because it needed to be held in reserve. What is that area and what financial impact would occur if you were to locate these wind turbines there at this time?
So right now we have a lease area, and we have the full lease area. And for future solicitations, we would like to be able to place turbines all over the lease area potentially. And if we received a ruling that we cannot place turbines closer than a certain distance, that would harm the company.
So in other words, you ultimately want to place turbines all over the lease area and not just the narrow area that is the subject of the layout that is here today. Is that correct?
Your Honor, I'm going to object again. We are here about the decision in this matter. We're not here about future solicitations or other rounds. We're here about the decision of going from the 8 to 12 megawatt in the lease area that was bid before this commission back in 2017. We're not here about future solicitations.
Mr. Coran, the commission did limit the scope of this hearing, but your witness opened the door for this line of questioning, so I'm going to overrule and allow Mr. Maloney to continue.
Well, the other basis of my objection, I'm sorry, I know that you ruled, Your Honor, is that essentially we're talking about going beyond the legal limits of the Maryland law. We have a statute that only permits these ORECs to be based on projects that are within 10 to 30 miles from the Maryland shore. Now we're talking about, areas that would be outside the legal relevance of the Maryland law. So that would be an additional objection for getting into
I'll rephrase the question to take into consideration the 30-mile limit of the OREC statute. So why would there be a financial impact on Skipjack if the commission required you or you otherwise relocated these wind turbines farther out than 22.7 miles, but less than 30 miles and still within the leasehold area? Why would the location impact your reserve values that you testified to that are very important to the company there?
I don't think I would like to. It's a hypothetical question, isn't it?
No, you've made it very real. You said in your testimony that this would cost the company a lot of money and have a severe financial impact if you were first forced to build farther out in the leasehold area. And I'm exploring you now whether that's commercially reasonable under the commission standards and what the costs would be and why they would even exist.
Mr. Maloney, if you would allow me to inquire of the witness. Mr. Graugard, counsel for the town of Ocean City is asking you, to the extent that you move your proposed project further out beyond 22 miles, but within 30 miles, you've referenced that would cost the company additional resources of some type. Counsel is inquiring of you, to what extent would that affect the company financially? Is that correct, Mr. Maloney?
That's correct. And specifically, the utilization of those reserve areas that he wants kept for future uses.
Is the witness able to respond to that?
If I isolate it to this project,
Yes.
and under condition that it doesn't have anything to do with other projects, we could probably do that. We would probably have to rearrange the turbines in with a third row for the closest two turbines.
Witness, Gravgard, you misunderstood my question.
If you look at, sorry.
My question is, to the extent that Skipjack wishes to move the project further out beyond the 22-mile proposed range, but less than 30 miles, you stated previously that there would be a financial impact on the company. Council for Town of Ocean City is asking what type of financial impact would the company realize?
And bear with me for a second. If we look at it in isolation, and if we look at it and we stay within what we have submitted with the COP, where we have a layout with 1 statute mile spacing, we can arrange the turbine in the turbines, 12 turbines, not in 3 rows, so that we move the two turbines to a different position.
Mr. Gravgard,
Consistent with what is in the COP, then it can be done.
Mr. Gravgard, is not relating to the arrangement or positioning of wind turbines.
Okay, so, but if we say that it's going to be further than 22.7, that would eliminate the innermost 2 turbines we see in that diagram you can see in Exhibit 21 of Ocean City.
Let me start over, Mr. Gravgard. I'm no longer looking at exhibit number 2021, the map. Council for Town of Ocean City is simply asking what financial impacts would Skipjack realize if the wind turbines were pushed beyond 22, but no more than 30 miles offshore. Financial impacts is the question.
If there are no further limitations done to the lease area as such, and it is isolated to this project and not impede further development of the site, that is a cost that we could live with.
Thank you, Mr. Maloney, your witness.
And when you say to that, your last phrase there, not impede further development, in other words, you would insist that you would have the right to develop other areas of the leasehold in the COP area. Is that correct?
That's correct.
Did I understand your testimony of just a minute ago that you started to say, or did say, that you could rearrange the wind turbine consistent with the COP in a way that would perhaps with a 3 and 3 and other layout or otherwise push them further out as long as you didn't lose any reserve area? Is that correct?
Yes.
So have you done a specific layout to look at that facility?
I don't know.
So you don't know if that would, but that would actually push it farther out from the shoreline and further minimize the impact on the view shed. Isn't that correct?
Objection.
Council, can you?
I would defer to Mr. Perkins on this issue.
Mr. Gravgard.
Yes.
When an objection is raised, do not respond, do not answer.
Apologies.
Mr. Maloney, can you rephrase and?
Thank you. And I'll clean up the question so we don't get into a view shed area that he doesn't claim expertise. So your testimony is that yes, it could be moved further out from the shore, consistent with the COP, but that you don't know, and that you could probably do that in a commercial, reasonably way, but you don't know if there's been specific layouts on that. Isn't that correct?
That is correct.
And with respect to, and do you know how much further out you could get it out consistent with the top and still be there?
So that is 2 miles, right?
Right. So this would be another 2 miles from what we have here in Exhibit 21, is that correct?
It depends on where on the coast you measure.
All right, but you're saying approximately 2 miles, but depending upon the coastal measurement, are we assuming that measurement point around 144th Street that Skipjack's been using all around?
I cannot say that with accuracy here.
All right, is it accurate that the best you could say is that it would be approximately 2 miles, but that would be subject to the layout and also the vantage point and also the measurement point in Ocean City, is that correct?
Yes.
And can I ask this? You told the commission a moment ago that you had a number of consultations with maritime and fishing interests on the specific layout. Is that correct?
On that, yeah, it says so in my testimony, yes.
Given that you knew of the substantial concerns from Ocean City and the community about the view shed, why didn't Skipjack have the same consultations about the layout that you had with the maritime industry to see if changes such as, for instance, the type of change that was just discussed could be pursued to minimize the view pack? Why weren't those same kind of, as the commission ordered in 2017, why didn't Skipjack sit down and review layout alternatives with the town of Ocean City as well, instead of just these other interests?
Objection.
It was quite a question, Mr. Maloney.
I'll shorten it up. Why did, given the concerns in the 2017 order about viewshed and stakeholders, why didn't Skipjack sit down and review these layouts with Ocean City?
With respect to that question, I will defer to Ms. Weber.
So is the answer you don't know?
Yes, because I was not the manager of this at that time.
And when did you become manager?
In December last year.
Now, with respect to the other projects in Long Island that are 30 and 35 miles off the coastline, is there any difference between those projects and the Skipjack project we're talking about here that would preclude you from doing those same distance, from doing what they're doing there? Is there any difference between the two projects other than the leasehold and COP approvals?
I'm not an expert on the conditions about surrounding, is it South Fork you are asking about?
Yes.
Yeah, I couldn't speak to that. I don't know.
Today, you're not aware of any difference other than the boundaries of the leasehold and the COP that would make these two projects any different?
Objection.
Sustained.
Do you know why Orsted chose to go 30 and 35 miles out, but only 21 and 22 miles here?
Objection.
Sustained. The witness says he's not aware of the South Fork project.
Now, with respect on your rebuttal testimony, you state that, well, let me strike that. When you talk about miles, is your testimony here today dealing with nautical miles or dealing with statutory miles?
When we look at these distances from shore, that was statutory miles.
Okay. Are you ever using so that we're clear and consistent in the record here, are you ever using nautical miles or are they all statutory miles?
What we've been discussing until now has been statutory miles.
Now,
There are hundreds and hundreds of pages in these proceedings. I couldn't say whether there are nautical miles that have snuck in somewhere.
Now, in the Commission's 2017 order, it said that Skipjack shall use its best commercially reasonable efforts to minimize the impact on the viewshed. Can you describe for me what those best commercially reasonable efforts were?
I believe I have described them, because what we have done is that we have arranged the turbines in 2 rows, and in a way that actually minimizes the part of the horizon measured in degrees from a point where you're standing on the coast. So that is what we have done. And when you look at the nighttime, then it's a question about the lighting.
Well, isn't it? Go ahead.
Sorry.
Go ahead. Answer.
Yeah. So when you look at nighttime, there is a product on the market which only activates lighting when aircraft are approaching, and we are in discussions with authorities about this.
It's true, is it not, that as far as the nighttime lighting, that the state of the market and the state of what is going to be required remains up in the air? Isn't that correct?
Objection.
Sustained.
Well, you don't know what the nighttime lighting and nighttime view sheds and technology are going to be. Isn't that correct?
For the project, you can say that. However, for a number of projects and a number of markets, we are looking at this technology, which only activates when there are airplanes in the area.
Well, with respect to the commercially available technology to minimize nighttime impacts, that technology is not fully available in the marketplace at this time. Isn't that right?
In the U.S. market, it doesn't have full approval. If it does become available, we will make it available for this project.
All right. But at this point, you don't know the status of the approval or even whether there's any likelihood that it will be approved at all. Isn't that correct?
I think we are optimistic.
Well, whether you're optimistic or not, there are a lot of challenges to it, including national security, impact on airline traffic, impact on maritime issues, and other national defense issues that have to be sorted out before that technology gets approval in the United States, correct?
That's correct.
And at present, in June of 2020, we still do not have approval, nor any particular date on which it may or may not get approved. Isn't that correct?
That is fairly accurate.
Mr. Chairman, I've probably got 20 or 30 minutes left. Consistent with your dictates, can we take a short restroom break now? We've been an hour and a half.
Let's take a 10-minute break. It's 11:28 now. We will resume at 11:38 precisely. Remind the witness not to have any conversations with his attorney during the break. Thank you.
All right, great. Thank you. Where's the restroom?
right, the commission will reconvene. Mr. Maloney, you may continue your examination of the witness. Mr. Maloney in the town of Ocean City, do you hear us?
Thank you. Chairman, thank you for the break. And during the break, we used the time productively to compress the number of questions. So my remaining questions will be much shorter than what I proffered to the chairman. And consistent with the chairman's direction, we're going to try to minimize the use of confidential information. But at the end of the questioning, I will have a few questions that will involve the use of information that Skipjack has designated confidential. And before I ask those questions, I will alert the chairman.
Thank you.
In Skipjack's, first of all, it's looking at Exhibit 21, if we can. And looking at the map, correct? Is the witness back on?
Yes, I'm back on.
Looking at Exhibit 21 and the map that is there, so that the record is clear, the leasehold area that Orchid has is the entire area that is outlined in blue. Is that correct? I can.
It is really difficult to see from that illustration.
We have something else I can show you if we want to. Yeah, this is from Skipjack response. This is your document, request number 1-3.
Council, I'm looking at the map. I don't see anything shaded in blue with the exception of the Atlantic Ocean.
It's very light. Let me see it on here. The trouble is, Mr. Chairman, that when it printed, I'm looking at the original produced by Jack. And
if you could hold on a minute, Michael Dean for PSC, if you could please put your microphone on mute.
Thank you, Mr. Chairman. Mr. Chairman, in referring to that document, which is Exhibit 21, but also it's Jack's own document that was given to us electronically as staff request in response to staff request number 1-3. The electronic copy, you can see the grid area represents the lease area, okay? And it comes out much more lightly when it's actually printed. Mr. Chairman, I think to solve this, so we don't have to spend a lot of time on it, I simply ask for a stipulation that the gridded area as produced by Skipjack is the lease area.
Objection, Your Honor. We don't stipulate to that, but if Mr. Counsel, the lease area is in Mr. Gravgard's rebuttal testimony on page 4. It's not in the document that you're referring to, which is our response to 1-3.
Well, I think it actually is shaded in 1-3. I'd be happy to take a look. Thank you, Counsel, at your suggestion. And you are suggesting, okay. And Counsel, what you pointed out for me is exactly the same area that I was looking at in 1-3 that didn't show up when it was printed. So thank you.
1-3 does not include the lease area. That's just the Atlantic Ocean.
Well, not when it's in graphics. It's identical. I can represent that in the electronic copy. It is identical because I just looked at it. and I'll proffer that to the commission. But we don't have to do that. Thank you, counsel, for that. If we could look at, sir, your rebuttal testimony at page 4.
Let's give everybody a moment to get there. Mr. Maloney, what line on page 4?
We're looking at the graphic on page 4.
Page 4.
Page 4 of your rebuttal testimony.
Yes.
Do you see the graphic that is there that takes up about 60% of the page?
What do you mean? Is it the lease area
Yes.
you're talking about?
Yes.
Okay.
Do you see that there?
Yeah.
And that's the area in the middle, which has number 6, has a large number of areas there. At the very bottom, it looks like 6827, goes all the way up to the top, 6237. I'm not sure my eyesight's capturing it all. 6234. But it's the large area which contains 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 blocks or quadrants that are set forth in there. Is that the lease area?
Objection.
What's the basis of the objection?
He's not citing the lease area for this provision, for this project, Your Honor, which is the dark shaded area.
Well, let me pin that down a little bit. Is it true that Ørsted and its affiliates owns or has a lease interest or has a lease for the entire area, shaded and unshaded, but that the area for this project is the shaded area? Is that correct?
Mr. Maloney, I'm going to stop you right there. Why don't we have the witness explain to us what we're looking at on this map? Because there's various shading in gray and in pink.
I think that'd be great. Thank you, Mr. Chairman.
Can the witness explain the illustration of offshore of Delaware, Maryland, what we're looking at here?
So what we are seeing on page 4 is just a sketch of the lease area that we have, and the Skipjack wind energy area is the southernmost part, which is highlighted. I think it's in a dark pink. Correct me if I'm wrong, because I'm colorblind. I think it's written here as that part is in a dark pink, and it has two squares in it. One which says 6477, and one which says 6527.
Okay. And when you were testifying earlier that some of the turbines could be moved farther out, were you referring to in the colored area or the entire area?
In the colored area.
And the area that's not colored, Ørsted and its affiliates or partners also has a lease there. But is it your testimony that that is not being used for the Skipjack project?
That is correct.
And what is it being used for?
Objection.
Basis for the objection?
Your Honor, this is the lease area associated with other projects, not with the Skipjack project that was bid back in 2017.
We're talking commercially reasonable alternatives, and we're entitled to probe what this going north is a commercially reasonable alternative here.
It's not owned by Skipjack, Your Honor. It's
owned by Ørsted and Ørsted affiliates or partners.
I'm going to sustain the objection.
Now, with respect to the where you located the turbines, your answer to the commission was, quote, that the layout of the turbines was primarily defined by 5 constraints: the boundaries of the lease area, stakeholder constraints, navigational constraints, geophysical constraints, and applicable law. Now, I'm going to take a slide. Those are 5 categories. Of the boundaries of the leasehold area, we've been talking about those. Are there any stakeholder constraints that would prohibit moving the wind turbines as far as 30 miles offshore?
I cannot, I don't have that measure on any drawing here.
Sitting here today, are you aware of any stakeholder constraints? In other words, concerns or objections by any stakeholders that would stop you from moving 30 miles out, farther out, or 30 miles out?
Wait, excuse me, just so I understand your question. What is it you mean when you say moving it further out?
Well, further out being, say, at least 30 miles out or perhaps less.
If you took these 2 rows of turbines and shifted them out so the closest one was 30 miles out, we would be outside the lease area.
All right, I just told you at the beginning of the question, I'm not talking about lease constraints. We've already talked about that. I'm asking about the other 4 constraints. One of them is stakeholder constraints. And with respect to stakeholder constraints, are you aware of any stakeholders that would oppose or object to you moving farther out?
We would be, if we moved beyond 30 miles, we would not be eligible for the OREX.
For the witness, you've answered the question, but when your attorney the question, I would ask that you stop your answer immediately. Give your attorney a chance to speak.
Thank you. I was not aware that it was his voice.
And I recognize we might have a little bit of a lag because of your distance. Mr. Maloney.
Thank you. The other 3 concerns was navigational constraints. Are you aware of any navigational constraints that would stop you from moving 30 miles, taking aside the leak for a minute, that would stop you from going 30 miles out or farther out than you currently are? Any navigational constraints you are aware of?
I don't know.
Are you aware of any geophysical constraints that would prohibit or stop Skipjack from moving 30 miles out or at least farther out?
We don't have any geophysical data to support having such an opinion. Our data and our data capture has been done within the lease area.
Is it your data capture? Does that show that there are no geophysical constraints to go anywhere within the lease area?
Our data is, are you saying within the lease area? Yeah, within the Skipjack wind energy area?
Yes.
I couldn't say.
So you don't know? You don't know is the answer. Is that correct?
That's correct.
And with respect to applicable law, the OREC law has an outer limit of 30 miles for the first round. Are you aware of any restraints on that?
I'm not aware of any restraints.
And with respect to the COP that was filed for location, and with respect to the COP that was filed with Boeing it was filed in April of last year, isn't that correct?
Can you point me to the place where I have stated that?
I'm simply asking you, isn't it true? You've referred to the in your testimony at the beginning of your testimony today. It's true that the COP that Skipjack filed for this project was filed in April of 2019. Isn't that right?
I believe that is true.
And it's been amended at least once since that time, isn't that correct?
I think so.
And there's nothing to prevent Skipjack from amending it again in the future, isn't that right?
That is right.
And Boehm has not taken any action on the COP to this point, isn't that correct?
That is not correct.
Well, what action have they taken?
Just recently, now it is the notice of intent is pending, and the first interagency meetings with other federal agencies took place or have taken place within the past 2 weeks.
But the COP proceedings still have not been made public, isn't that correct?
That is correct.
And with respect to the lease, there's nothing that would prevent Skipjack from asking to expand the boundaries of its lease area further offshore. In other words, there's no other leaseholders out there or any other maritime or navigational blockages that would prevent that from happening. Isn't that correct?
I don't know.
Well, are you aware of any?
No, but I'm not in a position to form a qualified opinion about it.
Who would know that?
I couldn't say.
Now, Mr. Chairman, at this point, I just have a few more questions, but they're on areas that Skipjack marked as confidential.
Okay. At this time, we'll work with the executive secretary and his staff to pull us off the public live stream. And Mr. Secretary, if you could give us instructions.
Yes, Mr. Chairman, I believe Amanda will cut the live stream first, and then we'll take it from there.
Okay. Let us know when the stream is cut.